Hello, everyone. I'm Ashley Banfield. This is Primetime Justice. There are more than 13 reasons why you should watch the runaway hit show of that same name on Netflix right now, if only to get inside the head of teenagers today and understand what drives them to the brink. That controversial show, 13 Reasons Why, has stirred a national conversation about teen suicide. Some school systems, including my own son's, sending letters home warning parents not to let your children watch it, at least without some guidance. It also tackles rape and bullying and the failure of adults to recognize their kids' concerns. And it ends with the parents suing the school after their daughter commits suicide because the school brushed off her sex assault. Tonight, there is a story out of Illinois that echoes many of these same themes. I want you to meet Corey Walgren, 16 years old, a hockey-playing honor student with good grades and no disciplinary record. And his parents say he was very involved at the school. So when Corey was called to the dean's office, he probably wondered why. What had he done wrong? Or maybe he knew. You see, the police suspected that Corey, a kid with no criminal history, had an X-rated recording on his phone of a consensual sex act that he had with a teenage classmate. To top it off, there's an allegation that he played that recording for other students to hear.
Consensual sexual relationship with a girl. They began to interrogate him and accuse him of having child pornography on his phone.
Once inside the dean's office, Corey was questioned about possessing child pornography. And according to the family's attorney, he was allegedly threatened that he could be put on the state's sex offender registry for possessing that audio.
They threatened him and scared him by providing him with false information without any justification. Literally threatened him and scared him to the point where this fine young man thought his life was over.
One of the school's deans called Corey's mom and then put Corey into a nearby office to wait until she arrived. But a short time later, school officials say Corey disappeared, left campus on his own. His mom, Maureen, told the Chicago Tribune what the school officials told her when she got there.
He looked at me and he goes, "Ma'am, do we have reason to be concerned for his safety?" Under normal circumstances, no, but I think you scared him pretty good. So yeah, I said, I do think we have reason to be concerned for his safety.
Her worst fears were realized a short time later. Corey had left the school and walked a mile to a parking garage in downtown Naperville. And then Corey jumped from the 5th floor. Now his parents have filed suit against the school and the city of Naperville, upset that he was questioned without either of them being present. They're accusing the school and the police of scaring their son to death. Stacey St. Clair is a reporter with the Chicago Tribune. She has interviewed Corey's mother, and she joins me now from Chicago. Stacey, why is it that the parents believe that this suit could go forward, that the school somehow shares in the blame of what happened to their son?
Well, it starts with what Illinois law says, and that's that juveniles in Illinois, if they are in police custody, cannot be interrogated without their parents being notified. And the police reports are clear that Corey was interviewed by police for 18 minutes at least before they tried to reach his parents.
And as I understand it, and correct me if I'm wrong, not just interviewed by the police, but by the dean as well for that 18 minutes. How is that any different from any of us being hauled down to the principal's office and being asked a lot of questions before things escalate, your parents are called, and then maybe you start talking about the possibility of charges?
Well, in this case, it was that there was a police officer there. I mean, the law is very clear in Illinois about what police officers can and can't do. There has to be almost a dire emergency for the parental notification not to take place. And the difference is if in Illinois, if Corey felt that he couldn't leave that room, if he didn't have permission to just end the interview and get up and leave the dean's office, then he was in police custody, and that law should have been applicable.
What is the school saying, if anything, understanding now with the specter of a lawsuit, it's very difficult to make any kind of communication or comment. But how is the school responding initially?
Well, the school has said from the beginning, at least to my question, in answer to my questions to them, is that Corey's death is a tragedy and that everyone in the high school is suffering, but that they have reviewed the procedures that took place that day and they believe they are in compliance.
Hold for a moment, if you will, Stacey. I want to bring in Terry Eckel. He is the attorney for the parents of Corey Wahlgren, and he joins me from Lisle, Illinois. Terry, thank you for joining the program tonight. I think I have the same question for you. Why is it that your parties believe they could prevail against the school when many would say he should have been brought to the principal's office? He should have been questioned if he had that kind of material on his phone.
Well, first of all, when they brought Corey down to the office, he was escorted in there to the presence of a police officer and someone from the school. And they then began to interrogate him. They were required under Illinois state law to advise his parents of that before they began the questioning. This was a criminal investigation that was being conducted. He was also entitled, because he was not free to leave, to his Miranda warnings. They didn't do that as well. And to make matters even worse, they took the telephone, they looked at it, and they knew there was no child pornography on it. At the very most, there was an audio recording of a sex act. That is not child pornography. It is not a crime. So what they proceeded to do, after having full knowledge that he had not committed child pornography and therefore could not be a registered sex offender, they proceeded to threaten him with that charge and tell him the consequences could be lifelong registration as a sex offender. And this young 16-year-old who had no prior police conduct was literally scared to death.
So, now, Terry, I'm just going to jump in only because from a practical standpoint, I understand your legal argument. From a practical standpoint, kids are brought into the offices of the principal, the vice principal, resource officers every day, multiple times across this country, and sometimes those resource officers are police officers as well. What is the difference between bringing a kid in to get to the bottom of something and what you're claiming is a criminal investigation requiring Miranda rights?
Well, first of all, if they're just merely looking for infractions of school rules, minor disciplinary matters, they can bring a student in and they can question him. If they're conducting a criminal investigation, which is what this was, a serious criminal investigation, it's an entirely different situation.
I guess, Mr. Eckel, how do you know that this was a criminal investigation? Because as it turned out, there was no intention, as the school has said, to actually charge him with anything, just to let him know this is serious. And when you have the kind of material on the phone that allegedly existed, you can be a registered sex offender at age 16. You can have your life ruined. What would be wrong with the school saying that? It's true.
The point is that's not what happened here. What happened here is they brought him down to the office to conduct a criminal investigation.
How do you know that that's what they did? How do you know that they weren't just starting to find out what happened?
Because it's in the police reports that we've seen. They are acknowledging that they were conducting a criminal investigation, and it was being done by a police officer. And there's no question, but that's what they were doing.
So, Terry, what would have been the appropriate procedure for the school to do? Call Corey into the office, not say a word to him, call his parents and have them arrive before letting them know what it was all about?
Absolutely. If they were going to conduct a criminal investigation, they could bring him to the office. They should have called his mother, just like they did after they had interrogated him, given the mother the opportunity to come down there to be present. And that's simply what Illinois law requires. And they didn't do it. And even worse, even if they're in good faith conducting this investigation because they think it's something serious, they had the telephone, they looked at it, and they knew he did not have child pornography on his phone.
So to that question, Terry, I want you to hold for a moment because Danny Savalos is with me as well as Areva Martin. They're both extraordinarily skilled attorneys. Danny, I want to get to the bottom of that. As a parent I don't want the school to call me before they have done at least the initial query of, what's your side of the story, young man? Because if there's a perfectly legitimate explanation for it, I expect them to do that before I'm called down for anything like this. But Mr. Eckel says from the get-go it was a criminal investigation. Is that true?
Well, I agree. As a defense attorney, I agree with the point that the police shouldn't classify this as an interview. This wasn't a criminal investigation. But there are a number of factors that go into deciding whether or not a juvenile's interrogation or any statements he makes are voluntary. And counsel has to acknowledge that even in Illinois, while it's ideal to notify the parent, the court will look at a number of factors, and it's possible that a juvenile can give a confession without his parents present. It is possible. But here's the catch. Even if what Terry is saying is true, even if this was a violation of his constitutional rights, it's the proximate cause. Was it reasonable and foreseeable that violating these Miranda rights would lead to suicide? Now, that's where I think the case has its challenges.
And Areva Martin, I want you to weigh in on this quickly, your thoughts about not only the essence of what Terry Eckel's saying, but also that second step where that child was put in a room, but he of his own volition left.
Well, the school had an obligation. No doubt they owed a duty to this young man, and they failed this young man. They shouldn't have been questioning him. 18 minutes later, they called his mom. So what was so dire that they couldn't wait 18 minutes before the mom arrived to begin this questioning and this investigation? And I think this family obviously has already talked to experts. They already know that they can prove proximate causation between the scare tactics and the abrasive kinds of allegations that were made towards him and his ultimate death. And I think the school should be held accountable for that, because they shouldn't bring kids in and threaten them with information that could have lifelong consequences, particularly when they know that information is false.
I think there's a lot of information that still has to come out. Areva and Danny, I want you to stand by. And also, Terry Eckel, thank you very much for being on the program. This is a suit at the minimum of $5 million. And listen, we could all be having this conversation right now because a young woman might have committed suicide because of what might have been played to other kids around the school. There could have been so many other outcomes from this. So it's very complicated, but I think this will be a fascinating look at what happened. So again, my thanks to Terry Eckel. Actress Sandra Bullock